Hello again. Do you remember the four elements of a legal contract? Think about it for a minute. If nothing else, by the end of this course, you'll be able to recite these at will. So they are offer, acceptance, consideration, and intention. We covered the first two, offer and acceptance, in a previous lesson. So today we're going to be talking about consideration and intention. In order for a contract to exist, both parties must give something up. Each party must give something of value for receiving something of value from the other. A promise that doesn't have consideration is called a gratuitous promise. When someone just promises something and doesn't ask for something in return, no contract exists, and the promise can generally be broken with legal impunity. And legal impunity means that you can't be sued and the promise is not enforceable by the court. So if you say to your friend Bo that you are going to give him your bicycle and then you change your mind, that can't be enforced. It wasn't a contract. There was no consideration on Bo's part. He wasn't giving anything up. A contract is basically a set of promises. So as I've just said, it requires an exchange between the parties. And each party has to give something up of value in exchange for something else of value. And of value doesn't necessarily mean it's money. Consideration can be goods, it can be services, as long as those goods or services have some value. Consideration can even be a promise not to do something. And we see this all the time in that a promise not to continue in a lawsuit in exchange for a settlement. So something may be headed to court, the company that is being sued decides to settle, and so the consideration is you don't keep going with the lawsuit. The adequacy of the consideration is not normally open to challenge. A judge won't decide what constitutes a fair and reasonable bargain. If I offer to sell you my car for $10,000, even though it's only worth $5,000, and you accept, then a contract is formed. The courts won't set aside the contract just because you got a bad deal. Remember, the courts expect the parties to a contract to take care of themselves. We see this time and time again. Consideration becomes a bit more tricky when the parties to a contract start to make changes in the contract. When parties to a contract agree to alter the contract in a way that benefits only one of them, the traditional legal perspective says that the alteration is unenforceable unless there is fresh consideration. I'm going to give you an example of this because it's a little bit convoluted. So if I agree to deliver a training curriculum to a client on June 10th, and I later let them know that I can't deliver it until July 1st, even if they agree, the new date is unenforceable. So I say, hey, I was going to do it on the 10th, can't do it now until July 1st. The company says, okay, July 1st will be fine. Really, because there is no mutual consideration, they could simply change their minds about hiring me and they wouldn't be breaching the contract. However, if I say I can't deliver it until July 1st, and as a result, I'm willing to give them a discount and they accept, then there is fresh consideration. I am giving them a discount and they are being inconvenienced by allowing me to change the date. In legal terms, the discount I'm offering in exchange for the delay is called fresh consideration, and this would make the contract enforceable. Next, we're going to look at a case that illustrates this principle well. So this is the case of Gilbert Steel Limited versus University Construction. Gilbert Steel was contracted to supply University Construction with a set amount of steel at an agreed upon price. Unfortunately, steel prices rose dramatically. Gilbert asked the university if they could pay more, and they said, yes, okay, the price of steel's gone up, we'll pay more. The steel was delivered, but then University Construction refused to pay the new amount and only paid the amount in the initial contract. So the legal question here was, is there consideration supporting university's promise to pay more? The resolution by the court was there was no consideration for the new promise, so it's unenforceable. The legal rules resulting from this case say that in situations like this, where there is a pre-existing legal duty, so they had a legal obligation to supply steel at a certain price, if nothing new extra, i.e. new consideration, is given for this new extra promise, then the promise is unenforceable. So we have a contract, I'll give you steel, you'll pay me a certain amount. Later on, I ask you to pay me more, you say yes, but get nothing in return. That promise is not enforceable. More recently, though, the New Brunswick Court of Appeal in NAV Canada versus the Greater Fredericton Airport Authority in 2008 ruled that a contractual variation that's unsupported by consideration can be enforceable. So this goes against the Gilbert Steel case. They said that a contractual variation unsupported by new consideration is enforceable provided that it is freely chosen, meaning there was no coercion. Then the new contract is enforceable. This decision by the New Brunswick Court of Appeal was more recently upheld in the case of Rosas versus Taka, 2018, which we're going to look at next. Okay, so this is the case of two friends and a loan gone bad. Rosas won $4 million in the 649 lottery. She then lent her friend Toka $630,000, and they agreed that it would be paid back in 1 year. The repayment was extended several times when Toka requested more time. It still didn't get paid. The action failed because Rosas didn't file the claim within 6 years of the original contract date, which was a rule in BC at that time. Rosas argued that the date to be used should be the last time they agreed on a new date, not the original date when the repayment was due. So the legal question here was, has the contract been varied in a binding way, even though there was no new consideration? So the Court of Appeal ruled that the contract had been varied in a binding way on the later date, despite the fact that there was no new consideration. Rosas won her case and Toka had to pay the money back. So the legal rule resulting from this case is essentially, in British Columbia, a freely chosen contractual variation is enforceable even without consideration. So think of it this way. There was a contract to lend money and pay it back. There was a due date. They extended that due date, and they did it willingly, even though nothing extra was being given for the new due date. This means essentially that there are two lines of authority in Canadian law regarding the enforceability of gratuitous contractual variations. So we're talking about the contract being varied without new consideration. So if I gave you a legal problem about variations in a contract, you could actually argue it either way, depending on which of these cases you use as precedent. There are some other promises where consideration is not required at law. These are called promises under seal. So essentially, the seal replaces the need for consideration because once a seal is affixed to the document, it is evidence of serious intent and acknowledgement that the contract is enforceable. No further consideration is necessary. A contract of guarantee is a really good example of this. It's a contract to perform the promise or discharge the liability of a third person in case they default. So, have you ever taken out a bank loan or known somebody who did? And did they need a guarantor, a co-signer? Basically, your co-signer signs a contract that says they will pay if you default, but they receive nothing in return. They're not getting anything in return, but they are taking on a promise of paying if you, the person who's taking out the loan, defaults. So that's a good example of a promise that's enforceable without consideration. The common law on gratuitous promises is really harsh, so courts can appeal to the law of equity. Remember, we talked about the law of equity before. It focuses on fairness. If the common law result would be unfair, the court can appeal to the law of equity. And promissory estoppel is an equitable principle. Basically says that someone who relies on a gratuitous promise may be able to enforce it if the reliance on another's promise cause you to change your position, and if you come with clean hands, meaning you haven't done anything underhanded during the time of the contract. The specific requirements for promissory estoppel are outlined on page 146 in the most recent edition of the textbook. I'll give you an example of when a gratuitous promise might be enforced. So let's say that you have a good friend. The good friend says to you, I am going to give you $10,000 so that you can start your own business. Your friend knows that you want to open a dog grooming salon. You rely on the promise and you go out and lease a premises and you buy equipment, and then your friend changes their mind. Well, under the common law, they're entitled to do that because they were getting nothing in return. There was no consideration. However, because you have relied on that promise and changed your position, financially in this case, as a result of the promise, it might be enforced by the court. Another type of promise enforceable without consideration is the partial payment of a debt. At common law, a gratuitous promise to accept a lesser amount left the creditor free to sue for the balance. So let's use an example to demonstrate this. Let's say you borrow $40,000 to start a business and the business fails. You're unable to make your loan payments and your bank sends the debt to collections. You work with the collection agency and you reach an agreement whereby you'll pay back 75% of the loan. The collection agency may agree to this because if they don't, you may declare bankruptcy and then they would get nothing back. At common law, even if an agreement was reached, you could still be sued for the balance of the loan later. Because this isn't fair on its face, some provinces have altered this by statute. So they have enacted law so that a creditor cannot sue for the balance once a lesser amount has been accepted. The last legal ingredient of a contract is intention to contract. The parties to a contract must have intended to enter a contract. For example, if I casually ask my friend for some financial planning advice, because they're a financial planner, I might be surprised when I receive a bill for the advice. You see, I had no intent to enter into a contract with my friend. I was just looking for some free advice. You can see how this might be tricky. Another example is this. When I was a little girl, my grandfather was always misplacing his pipe. He would say to us kids, whoever finds my pipe gets $100. We would all look for the pipe, but we knew that his offer of $100 wasn't a serious one. There was no intent to enter a real contract. In a business relationship, intention is presumed by the courts. So that is, when a promise is made in a business setting, the court will assume that there was intent to enter a contract. In terms of family agreements, the common law presumes that the promises are non-contractual, like with my grandfather and his $100 reward for finding his pipe. However, this presumption is subject to rebuttal, and we do see family members taking each other to court. In these cases, one side might argue that there was an intent to contract and may bring evidence of this. So if Sally borrows $500 from her sister Mandy and fails to pay it back, she may claim it was not a loan at all but was a gift. However, Mandy may be able to prove that it was a loan and that there was intent to contract by showing her maybe some text messages where they were discussing the loan and how it would be paid back. So this slide summarizes what I've just discussed. When it comes to a business agreement, the common law presumes that in the marketplace, the intention to contract is presumed. Business agreements are intended to be contractual, whereas in family agreements, common law presumes that the promises between family members are non-contractual. And so in order to enforce such an agreement, it must be shown that there was an intention to contract. Okay, so we're summing up this chapter about forming contractual relationships. You should remember that a contract comprises 4 essential elements: offer, acceptance, consideration, and intention to contract. You'll be saying these in your sleep now. Remember that before a contract can be formed, one party must make an offer on a complete set of certain terms. They can't be ambiguous. An offer can be terminated in a number of ways, including by revocation, lapse, rejection, counteroffer, death, or insanity. Assuming that an offer is still alive or on the table, the other party must unconditionally accept all of the terms of the offer for the offer to be considered accepted. Each party has to give something up. We call this consideration. And then finally, the parties must intend their bargain to be a contractual one. The law will enforce a promise that is not supported by consideration if the promise is under seal, if promissory estoppel applies, or if it is subject to special statutory schemes such as partial payment of a debt. Aside from these exceptions, the gratuitous promise is not binding, no matter how seriously it was intended. So that's it for Module 2, Lesson 2. I'll see you at the next lesson.